This hour, we're gearing up for this fast-approaching case by bringing you the 5 best moments from that fiery pretrial hearing on Friday. Now, we're going to start with the defense's arguments. The defense team is arguing that Officer John O'Keefe was killed at a house party. Take a look.
Defendant has stood here, defense counsel has stood in this court repeatedly, stood here and in other venues and in their pleadings, espousing various third-party culprit theories or scenarios. But now that it's time to actually try the case in the courtroom, I don't have a motion from the defense to admit third-party culprit testimony. So, and as you're well aware, I have to make findings before any mention of any third-party culprit evidence or even an opening goes before the jurors. You know, in order to admit it, given that I have no information at all, I mean, I don't know who the third-party culprit is, even after reading 4,500 pages of discovery. I don't know what motive a third-party culprit might have. I don't know how it's relevant. I don't know if it's remote or if it's current. I don't know if it's speculative or if it's relevant. I don't know if it will prejudice or confuse the jury. And if it's hearsay, I have a whole other series of factors I have to consider. So, Ms. Giannetti, are you pursuing a third-party culprit defense?
We are, Your Honor, and I'm prepared to address that. The Commonwealth has raised the issue, and I am prepared to address that today.
So you filed your motions first, and you did not raise it. So if the Commonwealth had not raised it, you did not move to introduce it, correct? I have no motion from
No, I understand.
You about it.
I understand, Your Honor. If you'd like something in writing for us, we can do that. I have a full argument prepared.
All right, so who is the third-party culprit?
We are under no obligation to name any specific third-party culprit.
How am I supposed... So you're prepared to argue all this?
I'm prepared to argue it, Judge.
All right, so we will get to that when we get to the Commonwealth's motion.
That's fine.
Now, the second thing I want to address, because, again, it's very important at this point, the motion regarding the DNA, regarding excluding the DNA. Mr. Lally, why should I not allow that motion?
For a couple of reasons, Your Honor. Number one, what I can provide to the court by way of update is that most of the testing with regard to that item is complete. So first and foremost, the item is hair. That was confirmed by the body testing prior to them conducting any sort of mitochondrial testing. The mitochondrial profile, the partial profile that was generated in regard to the hair sample is complete. The mitochondrial DNA profile in regard to Mr. O'Keefe's sample is complete. The preliminary analysis that I received by way of email from Bodie yesterday indicated that they were consistent with each other. I asked for some sort of preliminary report or something that I could share with counsel based on their lab's accreditation. That did not permit them to release anything by way of a report prior to it going through a full review process. My understanding is that not only that process, but the entire lab file should be produced by Tuesday. On top of that, what I would state as far as any sort of prejudice the defendant appears that they've suffered as a result of that, there is still zero reciprocal discovery that I've received in regard to anything from counsel. And then part of the delay, at least a portion of the delay in this specific testing, as the court is aware, as you've had a chance to review Bodie Technologies' observance policy as far as outside experts, there was a significant delay in hearing from counsel and for the defendant in regard to whether or not they wish to have someone present prior.
How long a delay?
I believe it was at least several weeks, if not a month. I mean, we spoke about it in person in December, and I don't believe that
My order was in November.
Correct. So when we received your order was in November. What took a little time on our part was to get the samples taken from the troopers in regard to the other testing, and in order to get all of those items shipped and transported from the MSPCL to Lorton, Virginia to Bodie.
When was that done?
Late November.
All right, let's talk some more about this case. Boy, what a power panel this is here. I have Matt Johnson, Court TV crime and justice correspondent in the studio, standing by remotely. I have attorney and trial advocacy professor Dante Mills with us, and Lieutenant Randy Sutton with us as well. Boy, oh boy, great to talk to you all. Okay, let's just start a little bit with you, Matt, here. This hearing on Friday, in terms of what was a bombshell? What really jumped out? You know, would you say to you, reporting on this case, it was the third-party culprit stuff?
I think so, because that's what led us to our breaking news on Wednesday, that the defense team cannot use any of that during opening statements. And really, we saw the backdrop of why she made that decision just now in Friday's hearing, because she was questioning them of why they didn't submit enough, evidence that they hoped to present for her to rule on that.
Right. Has to be relevant evidence, has to be evidence that has substance to it. It can't just be, oh, it was this person. You got to back it up. It has to be backed up in order for it to come in. Competent evidence. So we'll see what they've got. Not being able to say it in the opens, I'm sure they are devastated about this. Professor Mills, okay, tapping into your experience as a trial ed professor and as a criminal defense attorney, I want to make clear the distinction between a third-party culprit defense versus just the "it wasn't me" defense, it was somebody else. Would you kind of walk us through the big distinction and why the law has to be really particular in this area in order for the judge to let it in?
Absolutely. And just so we understand, in a criminal defense case, if you're defending yourself, you don't have to prove anything, right? The prosecution has to prove that you are guilty beyond a reasonable doubt. Your job as a defense attorney is not necessarily to prove anything. So you saying it wasn't me is essentially casting doubt on the burden of the prosecution. If you're trying to bring in a third-party culprit defense, it's a little further. It changes the burden a little bit, where you have to show that it's reasonably based. The rule is there because you are not allowed to just come in and just start naming people who may have committed a crime without any evidence to back it up. That's what that hearing was for last week, where the judge wanted to know, what evidence do you have? What can you show us to show that this allegation of a third party is reasonably based in facts and evidence? And that's obviously what they have some issues doing. So the judge said they can't talk about this in opening because the judge isn't impressed enough with the substance that they have behind it. But as the trial goes on, if they bring out testimony that supports this third-party culprit defense, then the judge can then open the door and allow them to bring this evidence in to show that not only was it not me, it was somebody else. That's that next step that they want to go to. But there's a screening process before they can get there.
Beautifully said, Dante. Thank you for that. And so here they were given an opportunity. The defense team was given plenty of latitude to go into whatever supportive evidence they had. And you're going to see in this show, we'll replay the clip, it just wasn't, it was, yeah, these people were at the house party, but it wasn't saying these people had a motive, opportunity, the means to kill Officer John O'Keefe and to try to cover it up, leaving his body in the snow, according to the defense theory. I've got a clip where David Yannetti, who's one of Kerry Reed's defense attorneys, was asked point blank by the judge, who's your third-party culprit? Who is it? Here's your chance. Lieutenant Randy Sutton, I'm going to come to you on the other side of this clip. Take a look at what he says to the judge when given the opportunity to say with specificity who it was that murdered the officer.
Mr. Yannetti, are you pursuing a third-party culprit defense?
We are, Your Honor, and I'm prepared to address that. The Commonwealth has raised the issue, and I am prepared to address that today.
So you filed your motions first, and you did not raise it. So if the Commonwealth had not raised it, you did not move to introduce it, correct? I have no motion from
No, I understand.
You about it.
I understand, Your Honor. If you'd like something in writing for us, we can do that. I have a full argument prepared.
All right, so who is the third-party culprit?
We are under no obligation to name any specific third-party culprit.
Lieutenant Randy Sutton, what'd you think of that?
I call that a tap dance. That was what that was.
I agree with you, Lieutenant.
It sounds like they're playing a game of Clue here. I'm not impressed with what the defense is doing here. They're throwing a massive smoke screen up, and I think they're really playing to the media and playing to the people that are outside that courtroom chanting her name in support, which I find a little strange to begin with as well. So far, the prosecution looks like it's in pretty good shape. The motions that have been put before the court by the defense are very, very shaky. So it's be interesting to see how they purport themselves as this trial continues.
Isn't that the truth, Lieutenant? I'm with you. I see a big, giant smoke screen, and I think that this defense team tried very hard to get this case kicked before trial. I think that was their mission from the outset. Let's create as much of a scene and chaos and make this seem like this woman is being framed to try to get rid of it. I think they've done everything in their power to do that. And now that it's gone forward, it's like, oh boy, here we are. We don't know what to say. Tap dance. Go ahead, Matt.
Well, you know, what I was going to add to that, yes, it's unusual to see protesters out in front for a defendant, especially a defendant that's an accused cop killer. But it's also unusual in this case that you don't have police in uniform during the hearings in support of their fallen friend.
The judge restricted that.
Yeah, but not during the pretrial hearings.
I know there have been police in the courtroom every hearing. I do know that.
Yeah, but usually, you know, in cases that I've covered in California and elsewhere, there is like a line of police in the gallery. I haven't seen that in the hearings that I've covered. In uniform. And yes, you're right. The judge did restrict that for the trial.
Yeah.
You know, observers and witnesses cannot wear their uniform in the gallery, just like Karen Reed supporters can't wear buttons or T-shirts.
Yeah, that's...
There could have been an order given by the agency. That happens very often. That doesn't have to come from a judge. It can come internally from the agency itself.
Oh, appreciate that,
That
Lieutenant.
would make sense,
Okay.
especially because the agency was under attack by the community, some members of, you know, in questioning.
And who knows, yeah, and who knows what their juice is, their reasoning. Yeah, if anyone's being paid to stand out there with signs. I have a lot of questions about this. We're going to talk some more. We've just got to hit our break. When we come back, prosecutors present a motion for body camera evidence, including alarming and very damaging statements that Karen Reed made. You're going to hear who she points the blame on her boyfriend's death to when she's taken into custody. We'll be right back.
We are underway in the trial of doomsday prophet Chad Daybell.
Prosecutors say they will seek the death penalty against him.
Investigators have recovered human remains at Chad Daybell's residence.
There's no way, Logan, I can never come up with this.
His wife, Lori Vallow Daybell, has already been convicted.
Now, will her husband end up with the same fate?
It's just so hard to know where the truth ends.
It's the doomsday prophet, Chad Daybell, on trial.
Welcome back to Court TV Live. I'm Julie Grant. Homicide defendant Karen Reed is claiming that there is a wide-ranging cover-up going on involving everyone from police to first responders to the district attorney's office. She's claiming she's the victim. She's saying she's at the center of a plot to frame, to be framed rather, for the death of her boyfriend, which she admitted to hitting him at the scene. By the way, admitted to hitting him at the scene when he was found in the snow in the middle of January on the morning of a nor'easter. Now, during the final pretrial hearing, the issue of her statements came up again, and not the I hit him statements, not those. These are some statements we hadn't heard before Friday. Statements caught on body camera video when state police rearrested her after the grand jury heard the evidence and decided to indict her on murder charges. Remember, police just charged her for manslaughter. It was the grand jury, after hearing from over 40 witnesses, that said, no, it's murder here. They voted for a true bill there. And so here in this video, she's arrested and she's sitting at the station with a trooper. Listen to what she says about what happened to John O'Keefe.
The defendant's arrest post-indictment by the grand jury in this case. So it's June 9th, 2022.
So that's why I have not seen the video itself.
Correct, and that's certainly something that the Commonwealth can provide for the court. But essentially, when she's arrested and during the booking process at the Milton State Police Barracks, the troopers who conducted that arrest were wearing a body-worn camera pursuant to their BWC policy with the state police. Counsel has a copy of the policy, counsel has a copy of the video, and essentially there are a number of different statements which provide sort of third, fourth, fifth, sixth, I'm not sure what number we're up to at this point, of sort of varying accounts that the defendant has provided to numerous people.
Can you give me an idea now? Do you know the substance?
So the substance of these particular statements is the defendant, Ms. Reed, continuously is told by Sergeant Buchanan to essentially stop talking. He's advised her of her Miranda and advised her to stop making statements, and repeatedly states that to her during the course of her making statements. But the sum and substance of it is she says something to the effect of, you know, are you in on the joke? And then makes some sort of reference to having witnessed Brian Albert and Colin Albert essentially smashed John O'Keefe's head into the taillight, indicating that that's how her taillight was broken. Doesn't make any sort of further statements about why she would then leave the scene after that occurred or anything like that. But these are, again, different accounts that have been made in direct variance to prior statements that she made January 29th to the troopers, to paramedics, to treating medical professionals, to Ms. Roberts, to Ms. McCabe, to the niece of Mr. O'Keefe, to a whole other sort of slew and variety of people with a different sort of variation on what transpired each time. So it's sort of inextricably intertwined with the fact that she's in custody.
How so? Is she in handcuffs? Is she in a cell?
She's seated at the booking desk or the booking rail in the state police barracks. So I mean, I don't need to make direct reference to it. It's just, again, it's something out of an abundance of caution based on sort of where it is and when it is that the statements are made, that it may naturally sort of come out as far as if the court wishes. I think it's something that the court can cure by issuing a curative instruction if there's any prejudice to be suffered by the defendant. But again, it is a statement by the defendant, which is admissible, as the court is well aware. And then it is sort of in the confines or in the context of her being in custody when she makes that statement. I certainly wouldn't be trying to elicit testimony that she was in custody, but it is kind of apparent that she is.
Can you have that here for this afternoon?
Yes, I can arrange for that.
So we can see it?
Sure.
All right, what's the defendant's position here?
For the record, it's a little bit lengthy as far as the entirety of the video. The portion that I would be submitting to the court is from 7 minutes and 4 seconds until 9 minutes and 55 seconds.
Okay. Can we? Thank you.
Okay. Can you explain to me what the process is right now?
Absolutely. So you're going to be booked just like last time. Go through the same process. It's going to be a little less time consuming because we're not going to do major case prints because we did those last time. Once you're booked and you go through this portion of it, we'll let you make a phone call just like last time. You'll make a phone call. Your parents we'll be able to bring you whatever other additional need, things that you need.
Yeah.
And then tomorrow morning, you'll go and be arraigned at Norfolk Superior Court on the charges that were. I'm sure you'll go over the charges again with you on the warrant.
But I'm on bail, so how can I be spending the night here again?
All right, so I'll explain that portion to you, as long as it's not going to interfere with you. Are you ready to go?
Yeah, I'm just waiting for Ram to.
Okay. So initially, your arrest was on probable cause out of the district court. Okay. So the charges that you were arrested on initially were out of district court, out of Stoughton District. That's where the arraignment was. It was district level charges. Today, grand jury indicted you on these charges, which is second-degree murder, vehicular homicide, and leaving the scene of a death. Okay? So those are the charges that grand jury indicted you on. So now you're being charged and will be arraigned in Superior Court, Norfolk County Superior Court in Devon. Okay?
So bail doesn't apply anymore?
Typically, I'm not, so we don't set the bail. But typically, once murder comes into play, people don't get bailed out.
So it's not manslaughter anymore, is that the difference?
That's correct. It's a higher degree of taking a life. Okay, so that's the charges that you're being charged with now. And you were indicted by grand jury.
Okay, you're aware he was beaten up by Brian Albert. I mean, we're all in on the same joke, right? My tail light was cracked and junk was pulverized.
Okay, you need to abide by the rights that were afforded to you. Okay, so you can talk if you want. If you want to tell us what happened, that's fine. We'll listen, but you were ready to do your rights, okay? And I'm sure he's going to do it again. All right. If you want to talk to us, you want to give us a story, definitely.
All right. So the judge, in terms of ruling on this admissibility and whether or not it can be known that she was detained, Matt, do we know anything yet?
So that's what we're waiting for. There are a number of motions that are going to be key for this case that we're waiting for, including statements made for state of mind, which this could include, statements made to the media, and also her hospital records, what she may have said there at that time. But I did want to mention the fact that, you know, unlike the Duerman case that we covered, this officer did the right thing. Like, kept on reminding her of the Miranda.
Right. The Chad Dorman case in Ohio where the confession got tossed. You're right, from not properly advising the defendant of his rights. Thank you for that, Matt. I want to talk about this video and how it may be helpful or harmful to both sides. So I'd like to ask Randy and Dante to take different sides respectively. Dante, looking at this from the defense side, how concerned would you be? What would you want in terms of whether it comes in or exclusions? We heard the prosecutor mention a curative instruction. Your thoughts on all of this, please.
Yes, this video can be key. And if I'm the defendant, I don't want this to come in. Any statements that she made is going to lock her into a story, and especially if their theory is something else happened that's not a part of that. And they're already on thin ice with the substance that they have for their third party culprit. Her saying anything that ties her to it or corroborates anything that the prosecution is saying is very damaging. It's very interesting in this particular case because the judge is the gatekeeper of information. And the jury won't see any of this if the judge doesn't allow. So all of this can exist. And if the judge says it doesn't come in and the jury doesn't hear these confessions, then that's a huge piece of the case that's missing, and it will impact the outcome. It could impact the outcome because if they don't hear these types of statements, it's less likely that they'll convict her. So I think statements like this are pivotal. And if I'm the defendant, I'm trying by any means necessary to keep these statements out.
Right, Dante, definitely. And I don't like the idea of a curative instruction. I'd rather do something like sever the video from the audio and isolate the audio so that just the important information, you know, about where she's saying that this fight happened and that's how her taillight got cracked, that comes in versus talking about her bail, you know, things that indicate she's under arrest and detained and could prejudice the jury against her. Lieutenant Randy Sutton, tell me, this was a bombshell in court on Friday. No No one in the media knew about this. This has not been something that came out. Of course, the defense team's not going to talk about it. The prosecutors haven't. How helpful do you think it is to the Commonwealth's case against Karen Read to prove that she hit him with her car?
Well, every statement that she makes after Miranda has the possibility of affecting her case. The trooper did do exactly as he should have in continuing to advise her that she shouldn't make any statements, but that's up to her. And these extemporaneous statements that she is making can be admissible, and usually they would be admissible. So I think that everything that she is saying has the possibility of negatively affecting her case, because what it does is it locks her into the statements that she has made. So it will be very interesting to see what the court's ruling is on this. But I can't see her ruling against the Commonwealth on this, because there was no there was no type of custodial interrogation that was taking place. So therefore, I think that she's going to keep it in.
Right, Lieutenant. I think you're absolutely right, as she should, because they are admissions, by a party opponent. The rules of evidence provide for those to come in. We just have to be careful not to prejudice the jury in any way with the detention part of it. Great points by you all. Stand by kindly, please. When we come back, we're going to take a look at what the defense said is their evidence to support this third-party culprit theory. Next. Welcome back to Court TV Live. Jury selection continues today in the case against defendant Karen Read, and we're unpacking some of the biggest bombshell moments from her hearing on Friday. And earlier you heard us talking about how her defense team is raising that third-party culprit defense, which is different from just saying somebody else did this. It's where you're blaming someone, and the law provides if you're going to raise it, you've got to be specific about it. You have to have particular evidence about motive, means, opportunity. It can't just be, mere dialogue and, oh, we believe it's this, we believe it's that. No, you have to back it up. And so here, you're going to see the judge offer to the defense team the time to show their evidence and show what they have to support their theory that they've been preaching about for months and months. Take a look.
The initial question is, why is there a third-party culprit defense? Why is it relevant? And we start, Your Honor, with the fact that our forensic medical examiner, Frank Sheridan, a forensic pathologist who has performed himself thousands and thousands of autopsies, has already submitted a sworn affidavit to this court that John O'Keefe's injuries are consistent with having been in a fight and are not consistent with having been hit by a car. Since he submitted that affidavit, the federal authorities have provided us with their reports, whereby FBI experts also corroborate that John O'Keefe's injuries are not consistent with having been hit by a car. They employed experts in biomechanics and kinematics who have reviewed the evidence in this case, and they've confirmed that the physical evidence essentially shows and doesn't show what Dr. Sheridan has opined. So therefore, if John O'Keefe was not hit by a car, that means that Karen Read did not kill him. And we know that John O'Keefe did not die of natural causes. This was not a heart attack or a stroke. John O'Keefe was injured. He was mortally injured. If he was not hit by a car, as both our expert and FBI confirmed, then he was attacked. And if he was not hit by a car, then there is a third-party culprit or culprits. So by asking this court to prohibit the defense from introducing evidence that others had the motive, opportunity, and the means to attack John O'Keefe, the Commonwealth is essentially asking this court to prohibit Karen Read from being able to defend herself.
So I don't think they're asking that you be prohibited from doing that. They're asking first to have you tell them what that is.
Right. Well, this is, Your Honor, I'm getting to that in terms of
right, so go ahead. You have your remarks.
That we're either required to give them or not. It is not our job to solve this case for the prosecution. It's our contention. They had the opportunity to do that, but they failed. It is not our job to name a specific third-party culprit. We do not have to prove that Brian Albert or Colin Albert or Brian Higgins or some combination of them intended to kill John O'Keefe. We don't have to prove that any of them attacked John O'Keefe such that he eventually died. They have to prove beyond a reasonable doubt that they didn't. But the fact of the matter is there is evidence that all three of them had a motive, had the opportunity and the means to attack John O'Keefe. Now, the Commonwealth cites Commonwealth versus Conkey in their motion, and as this court started the discussion on this issue when you first took the bench, Conkey makes clear that a defendant has a constitutional right to argue that somebody else may have committed the crime. And certainly, no, the acts of that person can't be too attenuated in time or method of operation, as Mr. Lally mentions. But in terms of being the right time period, Your Honor, you can't get any closer than their presence at the scene at the very time that John O'Keefe was killed. And in terms of the method of operation, given that we have evidence that he was not hit by a car and that he was attacked, all three of these men, either alone or in combination, possessed the ability to attack him with or without a weapon. I mean, that's a very low standard here. The Commonwealth acknowledges that. It's a low standard of simple relevance. And the evidence here establishes relevance. Now, Your Honor, I could go through with the court the specific evidence we have with regard to motive, opportunity, and means with regard to the three Commonwealth witnesses that I've named.
So go ahead.
Happy to do it. Starting with Brian Higgins. He was present at 34 Fairview Road on January 28th to 29th. He was close friends with the homeowner, Brian Albert. He had a prior romantic interest in Karen Reed. He did not expect Karen and John O'Keefe to be at the Waterfall, that bar, on January 28th. Karen Reed did not greet Higgins, despite the fact that they had previously exchanged flirtatious texts and that she had been at his apartment one evening, although there was nothing that took place between them any more than a peck of a kiss. At the Waterfall, Higgins does not engage with John O'Keefe. He does not say goodbye to John O'Keefe and Karen when he leaves, but before he leaves, he texts Karen, and that text was something to the effect of, well, with a lot of M's. We know that there was a preservation order from this court, your predecessor, Judge Krupp, to preserve his cell phone, and that Trooper Proctor gave him an edict, an order to serve on Brian Higgins, and he left it at the front desk of the Canton Police Station for him, and that Higgins, we learned through the federal investigation, Higgins became angry, demanded that Proctor come back, and he essentially upbraided him and read him the Riot Act, which shows a little bit about Higgins' personality. At the end of the night, everyone discussed going back to 34 Fairview, and when he gets back to 34 Fairview, he texts not Karen, he texts John O'Keefe at 12:20 a.m. He testified before the federal grand jury that he had no knowledge that they had been invited to 34 Fairview, but that is contradicted by this text message. And the inference is that he was coaxing John to come to that house. And, we're not saying this gives him a motive to kill John, but we don't have to show that. Any motive to feel hostility or animosity towards John O'Keefe goes to his motive. And, Your Honor, when Brian Higgins and Brian Albert are in that house, they're the only two people who are unaccounted for when the rest of the group was in the kitchen. And they claimed that they were looking at photographs together. And we have evidence that they were in the basement.
That right here, what we're listening to, that's the defense's proffer that they say they have to offer the court to say that it was these specific other people. Are you impressed with the proffer? I am not. Dante Mills, I was watching your face as you were taking notes and watching this. Talk to us, please. What are you thinking, please?
Listen, as a criminal defense attorney, and you know I always preach controlling the narrative, I think there's something here. There's a salacious detail of a jealous romantic interest in Karen Reed by somebody that was at the house at the time. They were out earlier, and he sent her a text. That confirms this. So I know that there's been a lot of smoke and a lot of talk, but if this comes in and they can say somebody in that house wanted Karen Reed and was pissed that he didn't have her, and she opened the door to leading him on to think that he can get her by giving him a kiss when she was at his house, I think that's enough for a jury to grab onto if they're looking for a reason to think there's a cover-up. That's all you need if you're a criminal defense attorney, is something to stick. And I think this type of information is salacious, it's gossipy. If somebody's looking for a reason, I think this provides a reason. And I think this is enough to allow the judge or force the hand of the judge to let this information in.
It is salacious and gossipy, and I believe the state wants it in, Dante. Matt, would you speak to that? They've put in some of their responsive motions about how Karen Reed was going after Brian Higgins, the ATF agent, that she planted one on him at John O'Keefe's house, that she snuck downstairs to walk him out and kissed him, and he was surprised.
So that's how it may help the defense, right, what Dante is saying, but how it may help the prosecution and the Commonwealth here is the fact that they're really trying to paint a motive of the relationship was breaking down. They went on vacation. There was allegations of infidelity. Some of the family members may testify that there were a lot of fighting. There are voice messages that Karen Reed left, allegedly saying terrible things.
Angry,
saying
right.
terrible things. So
Vicious
it could
voicemails.
go to a motive in their eyes.
Yeah, we have so much more to talk about after the break. Lieutenant Randy Sutton, hold your thoughts for just a moment. We got to hit a break. When we come back, I'm calling on you to see what you think of this case. We'll be right back after this.
We are underway in the trial of doomsday prophet Chad Daybell.
Prosecutors say they will seek the death penalty against him.
Investigators have recovered human remains at Chad Daybell's residence.
There's no way, Logan, I could ever come up with this.
His wife, Lori Vallow Daybell, has already been convicted.
Now, will her husband end up with the same fate?
It's just so hard to know where the truth ends.
It's the doomsday prophet, Chad Daybell, on trial.
How are we feeling today, Karen?
Good, Matt, good. You got this, Karen. Good luck, everyone.
Court TV Live. We're talking about defendant Karen Reed and how we may get a jury seated today. I want to bring back in my guest, my colleague, of course, Matt Johnson in the studio, attorney and Professor Dante Mills standing by remotely, and so is Lieutenant Randy Sutton, a highly decorated officer. He's also a radio show host. He hosts The Voice for American Law Enforcement. He's received multiple awards for life-saving incidents, for exemplary service. He's done training of officers all around the country and founded the Wounded Blue, which helps disabled officers. And we thank you for your service, Lieutenant. And I want to go to you, please. Tell me, this case is going to open up on Monday, we think. We think Monday is going to be the day. What are you most looking forward to seeing, Lieutenant, in terms of the case evidence?
Well, this is going to be a highly volatile trial in that there are so many accusations that are being made against the people that were in the house. And I'll tell you what the wrinkle is here, and that is that somehow the feds got involved in this. And I think that could have a huge effect on this trial, along with the exculpatory evidence, if that is accurate, from the other medical examination that took place. So there will be a massive attempt by the defense to discredit the forensic evidence that was collected at the scene by the state, and that will provide a lot of fodder for the defense. And remember, the defense does not have to prove somebody else. You know, they don't have to say, "Hey, Joe Blow did this." The burden of proof is on the state, and so that is where this. You can see that's the avenue that the defense is taking, is just to throw enough mud there to try and get the jury to say, hey, you know what, there's reasonable doubt here. It only takes one juror to say no, and this either becomes a hung jury or the defense, wins at the end of the day. So it'll be very interesting.
Yes, certainly. Lieutenant, we just have a couple more seconds, but curious how much you think Karen Reed's own statements are going to matter here. She was in hysterics that morning, and multiple people at the scene heard her saying that she hit John O'Keefe.
Yeah, that's critical stuff. The statements made extemporaneous to an investigation are all admissible, and so that's going to be really critical stuff.
This is such a great discussion. We'll leave it there for now. Lieutenant Randy Sutton, attorney Dante Mills, and my friend Matt Johnson, my co-TV colleague. Thank you all so much.